So what happened in court today and why was it surprising?
Well, this was sort of an unexpected culmination of over 2 years worth of litigation for 2 out of 5 of the valve turners. These were cases that happened across the country where people shut down tar sands pipelines in order to stop some of the most catastrophic impacts of climate change. And before these individuals engaged in these actions, they were trying to think about the long-term viability of the movement. And so part of their actions were intending to use what we're calling the climate necessity defense. And they were very well suited to be able to use that defense. So 2 years ago, there was a pretrial hearing where we asked the district court in Minnesota to allow us to put on a climate necessity defense. And surprisingly, the court granted that. And I say surprisingly because in the other 3 states, Washington, Montana, and North Dakota, the courts had just flatly denied us the necessity defense. And in each of those cases, we went through a jury trial process where the defendants were allowed to talk about why they did what they did and what the harms of climate change were that they were trying to avert, but they weren't allowed to put on expert testimony, and the juries weren't allowed to consider the necessity defense when they were deliberating on guilt or innocence. And so in this case, when the judge granted it, it was the first. And it's incredibly rare that a judge will allow a necessity defense. The necessity defense literally says that you had a choice of evils, and because the harm you were trying to avert was greater than the potential harm that your criminal act could have produced, that you can be found not guilty after admitting that you technically broke the law. So in these cases, they videotaped themselves and live streamed their actions. And after the district court granted us the necessity defense here in Minnesota, the state of Minnesota appealed to the Minnesota Court of Appeals, and the Minnesota Court of Appeals affirmed the right to use the necessity defense with a jury. And then the state appealed all the way up to the Minnesota Supreme Court, and the Supreme Court denied even hearing it and just affirmed the court. So one important aspect of this case today and this victory is that those rulings stand. And so here in Minnesota, the courts have ruled that climate defenders have the right to a necessity defense if they can meet the steep tests that the courts require in order to use it. So that was one, significant reality. Now, about a week ago, about 4 days before the trial, we had a hearing here in Bagley, what's called a pretrial conference, and the prosecutor had filed what's called a motion in limine, or a motion to exclude evidence. And these are routinely done pretrial. We try to limit their testimony. Their cops aren't allowed to call our clients eco-terrorists, and they're kind of a mundane part of the process. In this case, the prosecutor filed a motion in limine saying he didn't want any of our experts to talk about climate change, global warming, and civil disobedience, which was literally the heart of the climate defense. And we had 11 experts lined up to testify about everything from climate change and the harms including harm to human health, harm to forests. We had Minnesota's most famous weather guy who was going to testify about harms to Minnesotans. We had Harvard law professors who were going to talk about how there were no lawful alternatives left to try for these folks, which was another prong of the test. And we also had experts that were going to testify about the efficacy of civil disobedience as a tactic, and that these folks chose to shut down tar sands because it's the most polluting form of carbon emissions, and in fact they shut down tar sands for a day. But still, they were actually effective in what they set out to do. And if the tar sands pipelines had remained off, then obviously our tar sands climate emissions would have been reduced. And then in a really surprising ruling that came in at like 5 p.m., 3 days before trial, the district court denied basically granted the state's motion in limine and excluded all of our experts from being able to talk about the climate necessity defense. And so at the last minute, we were basically scrambling to reform the trial. And so when we started trial yesterday, we were picking a jury. We thought we had an incredibly limited, narrow window to be able to put on expert testimony about basically, the climate necessity defense. And we were really disappointed. And it was really surprising because after this same judge granted the defense, for him to basically take it away from us by not letting us put on expert testimony seemed completely contradictory. And we knew at that point we were going to have to take it up on appeal if they ended up convicted, et cetera, et cetera. So yesterday we started jury selection, and it was a long and rough jury selection process. We had the majority of jurors saying that they thought climate change either wasn't real or it didn't affect them. None of them thought that civil disobedience was ever justified under any circumstances. Maybe one of the more profound moments in the jury selection process was them passing the microphone from one to each other, and I had asked the question, whether they thought civil disobedience was ever morally justified, and they just basically said no, 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 and passed the mic all around. So, it was a fairly uphill battle just in terms of the jury that we had. Today we started opening statements. The state put on their case, and as we do with every criminal activist case, at the close of the state's case, we made a motion for judgment of acquittal, which basically means that the state did not prove their case beyond a reasonable doubt, and we are basically asking the court to dismiss the case. And in my 20 years of being a lawyer, I have never had a motion for judgment of acquittal granted. And in this case, the judge seemed to be reading from something he had written up already, and he basically went through the elements of the offense. This charge was a felony charge of doing damage to critical energy infrastructure, mainly pipelines. It's a somewhat new statute in Minnesota, and it's very specific. And basically the judge ruled that the state hadn't met its burden of proof, that it was basically trying to jam a square peg into a round hole, that what had happened here, a phone call to the pipeline, and even if they had temporarily turned off that safety valve, that did not meet the definition of significant damage or disruption to a pipeline. And so he granted the motion, which then dismissed all the charges against the defendants, and there's no basis for appeal. So the case is over, and it's a victory. Nobody has a felony conviction, nobody's going to prison. Our clients, though, didn't even get to put on their testimony. They didn't even, a big part of their action and what they intended to do was to have the opportunity to sit in a room with 12 or 14 local jurors and have the time to have an honest conversation with them about why a 30-year lawyer would risk going to prison for this cause, and how they did all this research and read all of this stuff and really made sure that what they were intending to do was safe to the community, safe to the environment, and would actually have the intended effect of reducing climate change. And that's an important part of why a lot of activists take the actions that they do. This jury and this community voted 69% for Trump, and a lot of, where we had room to sort of help the movement in this case was by talking to them and explaining, what is climate change, how does it affect them, what's the science behind it, why aren't our government officials doing anything? to fight climate change, all of those things would have come out in the trial, and they did not.
Which would have been an interesting conversation, especially how many pipeline families were in the room.
Yeah, definitely. And in all of the other cases, in the other 3 valve turner cases, well, I'll say the 2 that I was actually one of the trial lawyers for, they were really similar juries. They were conservative, they weren't activists. We had a lot of people during jury selection saying climate change is a hoax or a fraud, or climate change isn't happening, like you heard yesterday as well. But by the end of the trial, just based on the testimony of the valve turner himself, we had jurors shaking their hands, thanking them for the information that they provided to the community. After Leonard's trial in Montana, a whole portion of the town came out to the bowling alley and had beers with us and hung out with us, and it really seemed like it was a positive experience for the local communities as well as for the activists. And then I think finally, in this case, another sort of gift being left to the Minnesota climate defense community is that this critical energy infrastructure law was not successful in creating felons out of nonviolent activists. These laws are being passed all around the country. They are being pushed by the fossil fuel industry. They're literally buying legislation at the state level, and their hope is not only to scare activists out of doing anything at a pipeline, but it's also, they're trying to combat the moral shift of society. Like, more and more people are awakening to the realities of climate change. They don't want those industries in their community, and they're starting to realize that those corporations are putting profits above their family's health, and the community and the planet. And so oftentimes when you see industries like coal, like fossil fuels, taking those last gasps of unchecked profiteering, you see them trying to increase criminalization of people who are opposing them, whether it's through slap suits like we've seen in some of our other cases, or in this case where if that prosecutor had filed a misdemeanor criminal damage charge, he probably would have gotten it because they cut some locks. They did some minor property damage, but he didn't want to file that charge. The industry didn't want him to file that charge. They wanted the felony criminal damage to a pipeline charge because they were hoping that that was going to be a deterrent, and it backfired on them today. And so, we at the CLDC often think that these laws are really unconstitutional, not only because of the way they're written, but the legal system is not supposed to work that whoever can buy criminal law protection, gets it. That's not the way our system's supposed to work. We see it with the Animal Enterprise Terrorism Act. We see it with these critical energy infrastructure laws and these anti-protest laws. They think that by passing these laws, they're going to criminalize dissent and they're going to scare activists away. But hopefully today a message was sent that they're going to have lawyers, they're going to work really, really hard for years. We never stopped fighting to try to get those experts in. We never stopped turning every stone to try to win against the state and Enbridge, standing behind the state in this case, to win this case for our clients. And we're really relieved, and we're obviously gratified that all of that work paid off.
Are there any more specific ways that this victory will be meaningful to people fighting pipelines right now in Minnesota or Louisiana or states where there's critical infrastructure laws being put in place?
Well, I think that the state was held to the letter of the law that was passed, and that law does not criminalize nonviolent minor property damage like what occurred in this case. So I think that they are sort of going for the gusto, and they fell short in this instance. We did obviously have a discussion today, though, that these defendants have a lot of privilege. Not only are they white and educated, but they also were able to have a legal team of 3 lawyers working their butts off for them. You know, we obviously know that, like at Standing Rock, we had indigenous water protectors charged with felonies for being in a prayer circle. You know, so we definitely, you know, acknowledge that privilege has a lot of power, particularly within the legal system and the political systems that we're forced to try and operate under. But hopefully today's victory will give other lawyers and other activists a pathway forward, so that they will not feel the worst consequences of this type of law in Minnesota.
Mm-hmm. That's awesome. So as the climate movement and these pipeline fights continue, what role do you think CLDC and just in general high quality activist defense plays in helping these movements go forward?
Well, I think legal representation, legal support is vital. Not only like at the very beginning stages, you know, we want to make sure that activists know their rights, they know how to interact with the state and surveillance and infiltrators, you know, and everything else that's going on in the climate movement. So from the very early stages, you know, CLDC is there giving Know Your Rights trainings on all of these frontlines campaigns. But then I think, and that's important for a couple reasons. One, we want people to know what they're getting into before they get into it. But 2, we also do not want people to think that the climate necessity defense is a get out of jail card. You know, obviously there are multiple obstacles to overcome, even to just be able to assert that in court. And this was an example where even though we were granted it, in essence, the court took it away at the last minute in many respects. And even if we had been granted a jury instruction to the necessity defense, I'm not sure that a jury pool like what we had would have done that balancing and actually acquitted them based on the necessity defense. So it's really important for people to not think that this is like the magic pill that's going to get you out of criminal charges if you're out there engaging in civil disobedience. You know, I think that from our perspective as CLDC, like, you know, we want people to be prepared. We want them to have as much information as possible as they're deciding their strategies and their tactics in order to achieve their goals. But we also want them to know that, especially when the stakes are high, like in this case with felonies, that we've got their back. And if we take on their cases and we're representing them, we'll do everything in our powers to try to minimize the impact of state repression on their activism.
Well, it's been a roller coaster day.
Yes, it's been a roller coaster week. Yes.
Thanks for the update.
Sure.
They're releasing the bolt cutters. They're giving us back our property. Isn't that awesome?
We're going to go hold them on the courthouse steps like this.
Yeah.